In this video, I'm going to review with you the plea form we use in Pinellas County courts for change of plea in misdemeanor cases. So the judges want you to sign this anytime you enter a plea to a misdemeanor charge in Pinellas. So I'm going to go through exactly what this form is, what you're going to be doing, so you understand when you get to court what you're signing. So you'll see at the top of the document here, it says in the county court for the 6th Judicial Circuit in and for Pinellas County. So that's the courtroom that we're in. And it's the state of Florida, and we'll put your name in here and your case number over here. And it says plea form. And sometimes you hear this called a change of plea because we originally entered a not guilty plea on your case, so we're changing it. And it basically says that you're appearing in court and you've been advised by the judge of the charges against you, and you're entering a plea. We're going to check either guilty if we're admitting the offense, no contest if we're not admitting or denying it, or we just want to get it sentenced and get it over with, or if it's a violation of probation, we check admission here. So by signing the form, this is what you're doing. You understand what the charges are against you. So you and I have talked about that, and you know exactly what you're charged with. You know that you can plead not guilty, and we would have a jury trial in your case, or you understand that by pleading guilty, you're admitting the offense, or no contest, you're not admitting or denying. You just want to be sentenced and get it over with, and admitting the violation is exactly that. So you've got a right to a jury trial, or a non-jury trial if you're with the judge if you're charged with a violation of probation. So really this form is designed to make sure you understand that you're doing this freely and voluntarily, and you do not want to have a jury trial. You have the right to be represented by an attorney at the trial or all stages of the proceeding. You've got the right to confront and cross-examine the witnesses against you at trial, to compel your own witnesses to attend, and to testify or not testify, whichever you think is appropriate. The state attorney has to prove the case against you beyond a reasonable doubt. Okay, so you and I have talked about the case against you, and we're concerned about the state's ability to do that, so we're entering this change of plea. We've talked about the maximum and minimum penalty for each charge. So briefly, I know we've talked about it, but it's 1 year jail for a first-degree misdemeanor and 60 days jail for a second-degree misdemeanor are the maximum penalties for cases. But obviously you're not getting the maximum, you're getting exactly what we've talked about. The judge can question you about the offense, and a false answer can be used against you. Now, you're not really going to be asked about the offense. Most judges don't ask you, about the details of the offense. They're going to ask you, did you read this form? Did you understand it? Did you have a chance to talk to your attorney about it? Those type of questions, but we're not going to be talking about the details of your case. This certifies that you're a U.S. citizen, and if you're not a U.S. citizen, that there may be consequences related to your immigration status, deportation, or removal. I'm not an immigration attorney, so I don't give people any advice on immigration consequences. If you have a concern with that, we need to get you to an immigration attorney to discuss that. But this form certifies that you've had enough time to consider those issues and confer with counsel, and you're still ready to go forward with your plea. Number 12, if you've ever been convicted of a sexually violent or sexually motivated offense, you could be subject to additional penalties under the Jimmy Rice Act, or as a sexually violent predator. That doesn't apply to most people, and not all this is going to apply to you. Some offenses carry with them driver's license revocations. If your case does, you and I will talk about that, and you'll know exactly the impact of any plea on your driver's license. You're giving up your right to appeal any matters related to the judgment and sentence, and there's not going to be any appeal because we've entered into an agreement with the state attorney's office. We've entered into an agreement to a legal sentence, and there won't be any appeal, but if you wanted to, you'd have 30 days. There are going to be statutory fines and costs assessed, and you and I have talked about those. And they'll be totaled up and announced by the court. And if you're put on probation, you're going to have to pay probation costs. Those are usually $50 a month. We do want to get you off probation as soon as possible or limit that exposure, so we will try to do that. You're doing all this under oath. You're giving up the above listed rights. We will have an agreed upon sentence, so you'll know exactly what we're doing, and the judge will, and you're agreeing to let the judge oppose that sentence. On the second page, the plea is being done freely and voluntarily. Okay, no one's forced you or promised you anything other than what we've talked about. You agree there's sufficient evidence for the jury to consider your case, and you're satisfied with my help and representation. Of course, if there's any questions you have regarding that, please let me know now. You're not suffering from any mental, emotional, or physical problems which affect your ability to understand what we're doing, and you're not under the influence of any drugs, alcohol, or medicine which impair your ability to understand what we're doing in the plea. So the judge wants to make sure you're doing this freely and voluntarily, you're not doing it under any duress, or there's not anything impairing your ability to understand what we're doing. We will write in the terms of the plea agreement here, so the judge knows what they are. If jail is part of anything that we're doing, you'll get credit for any jail time that you've done. So if you are arrested and you spend a night or two in jail and you're ultimately sentenced to jail, you'll get credit for all the time that you've already done. But again, if you're not going to jail, you don't have to worry about this section at all. This is if you're not represented by an attorney, but you're represented by me, so you're going to sign here, and it just says you've discussed the agreement with me, you understand the contents, and you're competent to enter a plea to the charges. I'm going to put my signature in here, you can see it here, and then you're going to sign here. We'll either do this live in the courtroom, or if we're doing it remotely, I will email this to you with the ability for you to sign it either on your computer or your phone and then return it to me. Once that is done, we tender this plea to the judge. Again, the judge may ask you some questions about it and make sure you understand exactly what you have done here, and clarify that you know all the terms of the plea, and then they'll accept it and enter the plea. Of course, if you have any questions about this, let's talk about it. I like to do it this way by the video because it gives you plenty of time. You can watch the video twice if you like, and then of course we're going to talk about it before we do it, so any questions we'd be glad to answer. Thanks.